The Supreme Court chamber became very quiet as Justice Amy Coney Barrett leaned forward, her sharp gaze fixed on Representative Jasmine Crockett. The usually calm justice's voice was sharp and clear. "Congresswoman Crockett, you've stated many times that this case is about defending democracy, but your own words go against the very Constitution you swore to protect," Barrett said, her tone sharp and accusing. "How do you explain such a clear contradiction to this court and to the American people?" The room held its breath. Seasoned court reporters froze, pens hanging in the air above their notepads. This was a moment never seen before. A Supreme Court justice directly challenging a sitting congresswoman during oral arguments. The atmosphere was thick with tension as cameras captured Barrett's firm expression and Crockett's brief surprise. But then something unexpected happened. Instead of backing down, Representative Crockett slowly rose, straightened her jacket, and walked to the microphone. What she pulled from her folder next left Barrett clearly shocked, and would alter the path of one of the most important constitutional cases in decades. No one could have guessed that in the next 15 minutes, Crockett would not only defend herself, but completely flip the situation on Barrett with information that would make the whole Supreme Court bench unable to speak. Before we get deeper into this remarkable confrontation, be sure to like this video and subscribe to our channel for more breaking political analysis that the regular news won't show you. Hit that notification bell so you don't miss our special report on the biggest political battles happening now. Justice Amy Coney Barrett sat tall at the Supreme Court bench, her black robe perfect, her expression serious yet calm. At 53, Barrett had become a conservative legal symbol since her controversial confirmation in 2020. The former Notre Dame law professor and mother of 7 had been President Trump's third Supreme Court appointment, solidifying the court's 6-3 conservative majority. Legal experts often praised her sharp intellect and strict, word-for-word approach to the Constitution. Today's case involved a challenge to a new voting rights bill that Representative Jasmine Crockett had pushed through Congress. The law aimed to expand ballot access and federal oversight of state election rules, policies conservatives saw as federal overreach and progressives considered necessary safeguards. The stakes could not have been higher. If Barrett and the conservative majority struck down the law, Republican-led states would keep greater control over their election rules. If the law survived, federal standards would change voting access across America before the upcoming presidential election. For months, conservative media had been calling Crockett a radical, pushing an unconstitutional plan. "She's trying to take control of elections from the back door," declared headlines on right-wing news sites. Fox News commentators questioned whether Crockett, a former civil rights lawyer before entering Congress, was intentionally undermining state authority. Representative Jasmine Crockett, 43, had moved up quickly in political ranks after winning her Texas congressional seat in 2022. The former public defender and state representative had gained national attention for her strong advocacy and sharp legal arguments. With degrees from both Rhodes College and the University of Houston Law Center, Crockett had built a reputation as someone who came fully prepared and wasn't afraid to confront opposition directly. "I don't back down from bullies, whether they're in state legislatures or on the highest court in the land," Crockett had told reporters the previous week. "This bill simply makes sure every eligible American can use their constitutional right to vote without unnecessary obstacles. Anyone who opposes that should explain why they fear American citizens voting." These comments had apparently bothered Justice Barrett, who had been unusually outspoken during earlier procedural hearings, suggesting the law represented federal overreach into state matters, a constitutional line she believed should not be crossed. As the Supreme Court session started that morning, the chamber was filled to its capacity. Legal experts from both sides of the aisle packed the gallery. CNN and Fox News had reporters placed outside, ready to broadcast reactions. Before the hearing began, constitutional scholars had predicted a standard, if tense, proceeding following normal Supreme Court rules. No one expected what was about to happen. The Solicitor General had just completed her opening defense of the voting rights bill, when Justice Barrett unexpectedly focused her attention directly on Representative Crockett, who was sitting in the front row of the gallery. "Before we continue, I'd like to speak with Representative Crockett directly," Barrett said, breaking normal court rules. Chief Justice Roberts looked surprised but did not interrupt. As Barrett continued, Congresswoman, you've supported a law that fundamentally changes the balance of power set up in our Constitution. You've publicly stated this court has no business reviewing congressional legislation on voting rights. Your exact words on CN last month were, "The Supreme Court needs to stay in its lane." The room became tense as Barrett's criticism grew stronger. Such statements show a troubling disrespect for the constitutional separation of powers, the very foundation of our republic. Court observers exchanged shocked glances. This direct confrontation was almost unheard of in Supreme Court proceedings. The Chief Justice shifted uncomfortably, but remained silent as Barrett continued her pointed critique. Representative Crockett, you've built your career claiming to defend constitutional principles. Yet your legislation seems designed to get around the Constitution's clear delegation of election authority to states. This contradiction needs to be explained. It was a political and legal trap broadcast live to millions of Americans. Conservative commentators in the room could barely hide their satisfaction as Barrett systematically presented her case against both Crockett and the voting rights legislation. What no one knew was that Representative Crockett had anticipated this moment and had come prepared with information that would stun the court and the nation. The Supreme Court chamber stayed frozen in shocked silence. Justice Barrett's unprecedented direct challenge to Representative Crockett hung in the air. The Chief Justice, finally getting his composure back, leaned toward his microphone. While this is highly unusual, Roberts began, since Justice Barrett has addressed the Congresswoman directly, I'll allow a brief response before we return to proper procedure. All eyes turned to Representative Crockett, who nodded politely to the Chief Justice as she stood from her seat in the front row. Her face showed not fear, but calm determination. Court security initially moved to stop her, but Roberts waved them back, allowing Crockett to move toward the attorney's podium. "Thank you, Mr. Chief Justice," Crockett said, her voice steady and clear. "And thank you, Justice Barrett, for your direct questions. I welcome the chance to address them." Barrett's face remained serious, but a flash of surprise crossed her face at Crockett's composed attitude. The Congresswoman was not rattled as expected. "Justice Barrett," Crockett began, "you've suggested I disrespect the Constitution and this court's authority. With all due respect, my position has been consistently misstated." Conservative Justices Alito and Gorsuch exchanged skeptical glances. Justice Thomas leaned back, arms crossed. On the liberal side, Justices Sotomayor and Kagan watched with intense interest. Crockett continued, "My CNN statement about the court staying in its lane was specifically about hypothetical questions about the court potentially canceling the certification of election results, something entirely different from reviewing the constitutionality of legislation." She reached into her folder and held up a transcript. The full interview shows this context clearly. "I've never questioned this court's judicial review authority established in Marbury v. Madison." Justice Barrett frowned. "Congresswoman, regardless of that specific comment, your legislation tries to federalize election procedures that the Constitution explicitly leaves to states. Article I, Section 4 is clear on this matter." The tension in the chamber intensified. This was becoming a direct debate between a Supreme Court justice and a member of Congress, something never seen before in modern court history. "Justice Barrett, I'm glad you've cited Article 1, Section 4, Crockett replied, a hint of confidence entering her voice, "because that very section states, and I quote, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations." She emphasized the last part, her legal training evident. The Constitution explicitly gives Congress the power to establish federal election rules. My legislation works precisely within this constitutional framework. Several reporters quickly scribbled notes. This was not just a response, it was a constitutional counterargument delivered directly to a Supreme Court justice. Barrett's expression tightened. "Representative Crockett, I'm well aware of the constitutional text. The question is whether your specific provisions go beyond Congress's regulatory authority and interfere with core state functions. I appreciate that concern." Crockett nodded. "However, Supreme Court precedent has consistently upheld Congress's broad authority in this area. She quickly cited 3 previous cases supporting congressional action on voting rights. The exchange was becoming a high-level constitutional debate. Justice Kavanaugh leaned forward, clearly engaged by the substantial legal arguments coming from this unusual confrontation. Barrett shifted her approach. Your public statements suggest this legislation is meant to target specific states whose policies you personally disagree with. That raises serious equal sovereignty concerns under Shelby County v. Holder. Crockett did not hesitate. Justice Barrett, I've been very careful about this distinction. Unlike the provisions struck down in Shelby County, this legislation applies uniform standards nationwide. It does not single out particular states. The gallery murmured. Crockett was holding her own against one of the court's sharpest legal minds. Barrett pressed harder. Yet you've repeatedly claimed certain state laws are Jim Crow in new clothes. That suggests a targeted purpose. Describing historical parallels is different from writing targeted legislation, Crockett responded. The bill's text applies equally to all states regardless of my personal views of certain state laws. Justice Kagan nodded slightly, appearing impressed with the legal precision of Crockett's answers. Barrett changed tactics again. Your legislation includes provisions for Department of Justice preclearance of certain state election changes. That framework was specifically invalidated in Shelby County. For the first time, a smile flickered across Crockett's face. Justice Barrett, you've raised an excellent point that allows me to clarify a critical distinction. She took another document from her folder. The preclearance mechanism in this legislation differs fundamentally from the Section 4 coverage formula struck down in Shelby County. This bill establishes objective, contemporary criteria that apply going forward to all states equally, addressing precisely the constitutional defect identified in Shelby County. The legal reporters in the room looked stunned. Crockett was not just defending herself. She was giving a masterclass in constitutional law that directly addressed the court's previous concerns. Barrett's expression remained stern, but her tone had shifted slightly. This was not the easy dismantling of a politician's weak legal arguments she might have expected. She was engaged in a substantive constitutional debate with someone clearly familiar with the court's own precedents. Representative Crockett. Barrett continued, even if your legislation technically avoids the specific issues in Shelby County, it still represents a massive transfer of authority from states to federal agencies. The Constitution's federalist structure suggests the framers intended a more limited federal role. Crockett nodded respectfully before responding. Justice Barrett, I share your commitment to constitutional loyalty. That's exactly why I'd like to introduce something relevant to your concern. She took a bound document from her folder. This is a detailed historical analysis of the framers' understanding of congressional power over federal elections, including statements from Madison, Hamilton, and others during the ratification debates. Several justices raised their eyebrows. Crockett continued, these sources reveal the framers explicitly intended Congress to have final authority over federal election regulations as a check against state manipulation. Alexander Hamilton specifically warned in Federalist 59 that without this congressional power, the exclusion of the national government from regulating federal elections would leave the Union's existence at the mercy of state governments. The historical evidence was compelling and clearly unexpected. Justice Gorsuch, known for his interest in the founding understanding, leaned forward with clear interest. Barrett persisted. Historical evidence aside, Congresswoman, your public advocacy has suggested courts should simply defer to Congress on these matters. That's not how our constitutional system works. I agree completely, Justice Barrett, Crockett replied, surprising many observers with her ready agreement. Judicial review is essential to our constitutional order. My concern has never been about this court's review authority, but rather about making sure that review is grounded in the Constitution's text and history, including the Reconstruction amendments that significantly altered the federal-state balance regarding voting rights. The exchange had now lasted nearly 10 minutes, much longer than the brief response Chief Justice Roberts had authorized. Yet Roberts made no move to intervene as the substantive constitutional debate unfolded. Justice Barrett, seemingly determined to find a weak point in Crockett's position, shifted focus again. Representative Crockett, you've consistently called state voter ID requirements unconstitutional barriers. Yet, this court has upheld their validity in Crawford v. Marion County. Your public comments suggest a disregard for that precedent. This accusation hung in the air, potentially more damaging than earlier points. Questioning a politician's knowledge was one thing. Suggesting they disrespected court precedent was another. Crockett took a measured breath before responding. Justice Barrett, I have never stated that all voter ID laws are, by definition, unconstitutional. My concerns, consistent with this court's precedents, focus on implementation details that can create unfair burdens. She reached for another document. In fact, in my time in the Texas legislature, I co-sponsored a bipartisan bill that included voter identification requirements with appropriate accessibility provisions. My position has been consistent with the balancing test this court established in Crawford. Justice Barrett appeared momentarily caught off guard by this evidence of Crockett's more moderate legislative record. The tension in the chamber had changed. What began as a justice's attempt to challenge a congresswoman had become a sophisticated constitutional discussion that was captivating the entire court. But no one was prepared for what Representative Crockett would reveal next. Evidence that would completely shift the dynamics of the hearing and leave Justice Barrett genuinely speechless. The Supreme Court chamber remained completely silent as Representative Crockett reached once more into her folder. Justice Barrett watched with narrowed eyes while the other justices leaned forward, fully engaged in this unprecedented exchange. Justice Barrett, Crockett said, her voice now carrying a quiet confidence. You've questioned my respect for this court's authority and precedent. I want to address that directly. She withdrew a document that appeared to be a law review article. I've studied your scholarly work extensively, including this 2017 article you wrote for the Notre Dame Law Review, titled Precedent and Jurist Credential Disagreement. Barrett's expression registered surprise as Crockett continued, in this article you wrote, and I quote directly, I tend to agree with those who say that a justice's duty is to the Constitution, and that it is thus more legitimate for her to enforce her best understanding of the Constitution rather than a precedent she thinks clearly in conflict with it. Crockett let the quote hang in the air before continuing. You further stated that the public response to controversial cases like Roe reflects public rejection of the proposition that stare decisis can declare a permanent victor in a divisive constitutional struggle. Murmurs rippled through the chamber. Crockett was quoting Barrett's own academic writings about the limited power of precedent, effectively using Barrett's past words to counter her criticism about respecting court precedents. My point, Justice Barrett, Crockett continued respectfully but firmly, is not to criticize your thoughtful scholarship, which I genuinely respect. Rather, it's to highlight that constitutional interpretation inherently involves principled disagreement, something you yourself have eloquently defended. Barrett's face remained calm, but the slight tension in her jaw revealed her discomfort at having her own words turned back on her so effectively. But Crockett wasn't finished. She pulled out another document. Additionally, I'd like to address your concern about federal overreach into state election administration. She held up what appeared to be a printed email. My office submitted a Freedom of Information Act request regarding the development of model election legislation by various organizations. We received this communication between the Heritage Foundation and state legislators, explicitly stating their model voting bills were designed to ensure partisan advantage regardless of demographic voting patterns. The chamber erupted in gasps. Several journalists rushed out to report this revelation. This document, Crockett continued, once the room quieted, demonstrates precisely why the framers gave Congress ultimate authority over federal election regulations as a check against state manipulation for partisan advantage. Justice Sotomayor leaned forward. Representative Crockett, is that document part of the official record in this case? It was filed in our supplemental brief last week, Justice Sotomayor. Crockett confirmed. Page 47, Appendix C. Chief Justice Roberts frowned, flipping through his papers to find the reference. Several other justices did the same. Justice Barrett attempted to regain control of the exchange. Representative Crockett, a single email doesn't establish a pattern of... You're absolutely right, Justice Barrett. Crockett interjected politely but firmly, which is why we've included 17 additional communications in Appendix D showing a coordinated multi-state effort to restrict voting access, specifically in communities with high minority populations. She did not wait for a response before continuing, but most relevant to today's discussion is Appendix E, which contains communications directly citing your confirmation to this court as the green light to implement Phase 2 of the Election Security Initiative without fear of judicial interference. The chamber fell completely silent. Crockett had just revealed documents suggesting certain state officials viewed Barrett's confirmation as permission to implement voting restrictions they believed she would uphold. Justice Barrett's face flushed. Representative Crockett, I had no knowledge of... Of course not, Justice Barrett, Crockett said quickly. No one is suggesting you are personally involved. These communications simply demonstrate why the Voting Rights Act has been necessary and why Congress must keep its constitutional authority to regulate federal elections when states act with discriminatory intent. The dynamic had completely shifted. What began as Barrett's attempt to challenge Crockett had turned into Crockett effectively demonstrating the very need for the legislation under review. Justice Kagan spoke up. Representative Crockett, these documents raise serious factual questions about the motivation behind certain state voting laws. Can you clarify when these were obtained and verified? Yes, Justice Kagan, Crockett replied. These documents were obtained through legal discovery in parallel voting rights litigation in federal district courts. Their authenticity has been verified under penalty of perjury, and none of the authors have disputed their contents, despite having the opportunity to do so. Justice Kavanaugh, who had been reviewing the appendices, looked troubled. Appendix E's communications appear to explicitly discuss methods to reduce turnout in specific demographic groups. That raises obvious 14th and 15th Amendment concerns. Precisely, Justice Kavanaugh, Crockett agreed, and that constitutional concern is exactly what our legislation aims to address. Not by targeting specific states, but by establishing uniform national standards for federal elections that protect all voters, regardless of where they live or which party they support. Justice Barrett, attempting to recover from the unexpected turn of events, shifted to procedural grounds. Representative Crockett, while these documents are concerning if authentic, this court's